Hi everyone, this is Pennsylvania attorney Evan Gutman presenting video 18 of my legal education series. The videos address the good moral character standard for admitting a person into the practice of law and presenting them with a law license so that they engage in the practice of law. The videos are based upon my book titled State Bar Admissions and the Bootlegger's Son, which I wrote several years ago, many years ago actually. I published it in 2002. The complete content of the book is available on my websites. I have two websites. One is titled heavensadmissions.com and the other is a website titled gutmanvaluations.com. Both websites also contain a supplement to the book that I wrote years later after publication of the book. Additionally, both websites contain a fictional novel I wrote titled Heaven's Admissions Process. The fictional novel is kind of like a lighthearted, comical, somewhat humorous, hopefully an enjoyable book for everybody. It addresses the criteria for being admitted into heaven and compares it with the good moral character standard for obtaining a law license on earth. There is a PDF associated with each one of the videos, which you should be able to obtain from the website that you're viewing this on right now, hopefully. If you can't access the PDF for any reason, the PDFs are also available on both my websites, gutmanvaluations.com and heavensadmissions.com. So today I'm going to, in video 18 here, I'm going to continue my examination, analysis, and description of important U.S. Supreme Court cases addressing the good moral character standard. In video 17 preceding this, I started that analysis, and today I'm going to examine 6 more U.S. Supreme Court cases. The first one is titled In Re Anastoplo. It's a 1961 U.S. Supreme Court case. Now, Anastoplo was the child of immigrant parents. He was an adult, but his parents were immigrants. And as previously indicated, many of the bar admission cases pertaining to the good moral character standard address people being excluded from the profession decades ago who were primarily immigrants, black, Jewish, or women. The bar admissions process, as I've repeatedly emphasized, was designed to exclude minorities, and to do so utilizes a subjective assessment of good moral character as opposed to an objective assessment of actual conduct, which is the way I feel it should be. So Anastoplo, he refuses to answer a question, which is whether he was ever a member of the Communist Party. The court rules against him, and his application as a result at the U.S. Supreme Court, he receives an adverse ruling. But what's interesting is that when he applied to the bar during the bar examination, the questioning of him at the hearing, one of the bar examiner committee members said that they did not have a per se rule of exclusion if he doesn't answer a question, and that refusal to answer a question would not automatically exclude him. Now, he loses at the U.S. Supreme Court, but what's interesting is his background was impeccable. It really was. During the hearings, not one person could be found who would say anything faintly derogatory about him. The only reason he's denied admission is because he refuses to answer the question as to whether whether he ever was a member of the Communist Party, based upon his position that infringed upon his constitutional First Amendment rights, and he was entitled to not answer an improper, unconstitutional question. So nobody can say anything faintly derogatory about him. He served in the Air Force during World War II, flying as a navigator in every major theater of the military operations of the war. He received an honorable discharge. There was not one statement about his life or conduct that casts doubt upon his fitness for admission, other than his refusal to answer the question as to whether he's a member of the Communist Party, whether he ever was a member of the Communist Party. And he challenges the validity, the constitutional validity of the questions. At subsequent hearings, matters in the rift between him and the committee members widens, and their relationship with each other, to state the matter mildly, goes sharply downhill. This case represents the bar admissions process at its absolute worst. During the hearings, he is ultimately then asked about his, quote, possible association with a wide score of organizations, including the Ku Klux Klan, fascists, every single organization on the Attorney General's list, the Democratic Party, the Republican Party, and the Communist Party. The committee members then proceed to ask him whether he has a belief in a supreme being. So he's getting asked all these questions after he just refuses to answer whether he's ever been a member of the Communist Party. And the court does rule against him. A stinging dissent on the ground that he basically had to answer the question. A stinging dissent is issued by Justice Hugo Black, who historically has been a major supporter of the applicant's rights during the bar admissions process. Justice Black notes the sincerity and devotion of Anastopoulos. He asserts that the entire course of Anastopoulos' life was one of devotion to his country. And Justice Black stresses the need to illustrate that the consequences of the bar of not affording First Amendment protections to applicants is dire. It really is. Anastopoulos was a man victimized by the traditional state bar witch hunt, subjected to intense scrutiny in so many areas after he refused to answer the initial question as to whether he was a member of the Communist Party. He is ultimately denied admission based solely upon his refusal to answer unconstitutional questions because no incriminating information could be found about him and no one would say anything negative about him. And he had served his country for many years. Next case I'm going to look at is titled NAACP, which is a civil rights organization. I'm sure many are familiar with it. NAACP versus Button. This is a 1963 case, and it's actually one of my favorite U.S. Supreme Court opinions. I really like this opinion a lot. Next to Ex parte Garland, which I've discussed extensively in video 17, as well as other videos previously here, NAACP versus Button may be maybe my second favorite U.S. Supreme Court case, because I thought their opinion was fantastic. What happens in NAACP Button is it's a 1963 case, and in 1954, the U.S. Supreme Court had handed down Brown versus Board of Education, which ruled that segregation by race in public schools violated the Equal Protection Clause of the 14th Amendment. Now, the losing litigant in Brown was the state of Virginia. Having lost the Brown versus Board of Education case, the state of Virginia nefariously tries to circumvent its holdings by adopting a series of unconstitutional ordinances that are designed to frustrate the Brown versus Board of Education opinion. And one of these statutes that they enact, these unconstitutional statutes that they enact, makes it an offense for certain organizations to solicit business for an attorney. Now, it's doing this on the ground that such constitutes the unauthorized practice of law. The NAACP at that time was in fact devoting much of its funding and energies towards furthering an extensive program of assisting litigation on behalf of its own charitable organization purposes and civil rights purposes. And in doing so, what the NAACP would do is they would finance the attorney fees for the litigants that they selected and hire attorneys on their behalf. State of Virginia says, no, Dice. You don't pay for attorneys for impoverished individuals to further civil rights. That constitutes the unauthorized practice of law. State of Virginia says, no, this is within the legitimate scope of professional regulation. The U.S. Supreme Court rules that State of Virginia is wrong, and what the NAACP was doing by financing litigation to further civil rights goals was allowed, and as a result, the Virginia statute was unconstitutional. The U.S. Supreme Court, in its opinion, asserts that in regards to the state of Virginia's contention that such is within the scope of professional regulation, the U.S. Supreme Court asserts a state, this is important, a state may not, under the guise of prohibiting professional misconduct, ignore constitutional rights. And that's what Virginia was doing. They were saying, hey, this is professional regulation, and as a result, it supersedes the constitutional rights of the litigants needing help and the NAACP. In addition to that, the court notes, quote, thus it is no answer to the constitutional claims asserted by petitioner to say that the purpose of these regulations was merely to ensure high professional standards and not to curtail expression. Next case I'm going to look at is a case titled Wilner versus Committee on Character and Fitness. This is also a 1963 case. And it demonstrates that sometimes bar admission proceedings can take a lengthy period of time. The bar applicant Wilner presents the case of a man who is trying to gain admission to the New York State Bar for a period of 25 years. It begins in 1936, and after he passes the bar exam in 1937, he is told about a letter from a New York attorney, he's trying to get in the bar, and an attorney writes some incriminating stuff about it. He's promised a confrontation with the attorney in order to address the attorney's contentions. And the bar committee asserts that he will, in fact, get that right to confront the individual making the allegations against him. That promise is then broken by the committee. They don't allow him to confront the attorney who made the allegations against him. In 1960, 23 years later, he files his fifth application to the New York State Bar, which is denied without opinion. By the way, during the interim, he had become a certified public accountant. And I'm a certified public accountant in addition to being a Pennsylvania attorney. So I love that. The lead opinion of the U.S. Supreme Court rules that he did have a right to confront the individual who was making the allegations against him, and they rule in his favor on the grounds that he had a right to procedural due process that was violated by the State Bar. The next three cases, I've spoken about them in an earlier video. The next three cases are U.S. Supreme Court opinions that were all handed down on the exact same day, which is February 23rd, 1971. The cases are In Re Baird. The second case is In Re Stolar. And the third case is Law Student Civil Rights Council versus Wagner. Now, the interesting thing about these three cases, which when taken in conjunction with each other, they resolve nothing. Because the bar applicants won in Baird and Stolar. But the bigger case, which was Wagner, Law Students Civil Rights Council versus Wagner, the bar won. The applicants lost. In Baird and Stolar, the applicants once again refused to answer questions on the grounds they were unconstitutional related to their affiliation with certain organizations, mainly the Communist Party. And they refused to answer them on the grounds that they infringed upon their First Amendment and Fifth Amendment rights. What's interesting, and in the Wagner case, it was a broader attack. The Wagner case involved more than just one bar applicant. It involved a group of bar applicants, none of whom had even been denied admission to the bar. They hadn't even denied admission to the bar, but they basically were challenging the questions that were being asked on the grounds they infringed upon their First Amendment rights on a broad basis. So the court rules in favor of the applicants, the two applicants in Baird and Stolar, but it rules in favor of the bar on the bigger challenge, which is the Wagner case. Now, all three cases are decided by 5-4 opinions. And the man who is probably most responsible for leaving the bar admissions process in a mess is Justice Stewart. Because Justice Stewart rules in favor, in a concurring opinion, of Baird and Stolar, but he writes the lead opinion ruling in favor of the bar in the Wagner case. How Justice Stewart could possibly rule in favor of the applicants in Baird and Stolar and then rule against the applicants in the Wagner case boggles my mind. He's the individual precisely responsible for the good moral character standard assessment standard being a mess. The U.S. Supreme Court does not like this issue. They really do not like it. And since February 23rd, 1971, so far as I know, they have not addressed it squarely ever again. And those three cases left them realistically with no guidance whatsoever. In the Stolar case, as pointed out previously, Justice Black's lead opinion points out that the good moral character standard is essentially similar to what was occurring during the Red Scare, the McCarthy era. He writes as follows, quote, "These cases which concern inquisitions about loyalty and government overthrow are relics of a turbulent period known as the McCarthy era, which drew its name from Senator Joseph McCarthy from Wisconsin. We have just referred in our opinion in Baird versus State Bar, Arizona, to the confusion and uncertainty created by past cases in this constitutional field." And the other thing that's interesting is in the Baird case, which involved Mrs. Baird, who was a graduate of Stanford Law School. She didn't have a single mark against her moral character, but she refused to answer whether she had ever been a member of the Communist Party or any organization that advocates overthrow of the government. But here's the thing. The reason she refuses to answer is brilliant on her part. In my view, she had a brilliant argument, which is that she doesn't know whether the organizations advocate this stuff or not. Because she did give a complete list of the organizations that she had been a member of. She gave a list of the organizations she was a member of, but she refused to answer whether they advocated overthrow of the government on the grounds that she don't know what these organizations do. And the organizations comprised the following that she was a member of: the church choir, the Girl Scouts, the Girls Athletic Association, Young Republicans, Young Democrats, Stanford Law Association, and Law School Civil Rights Research Council. And notably, the last one, Law School Civil Rights Research Council, that was the Wadman case. Law School Civil Rights Research Council versus Wadman. So anyway, I hope you found this interesting, and we'll have the next video on within the next day or two or three or so. And remember, love right, don't fight. Bye.